Good afternoon. Happy Saturday, part 2. We've already gone over the complaint for Bobby Law / Fred Gutierrez. And now we're going to go over the immediate motion to dismiss that was filed by the judge, Timothy Atkins, and the prosecutor, Nicholas Graham. And their motion to dismiss, just so you know, is pretty well founded. As will be addressed below, this motion to dismiss should be granted since both defendants are entitled to absolute immunity. I'm going to focus primarily on the immunity of the judge. Prosecutorial immunity is fairly similar. I don't necessarily need to go into it. Suffice it to say that it exists. And they also argue the complaint is barred by the Rooker-Feldman doctrine. The Rooker-Feldman doctrine is essentially the district court can't act as a de facto court of appeal for a state trial court decision. The proper process, and this is what attorneys get paid the big bucks for, not suing judges, but following the proper process to get the results for the client, because that's how you get the results, is by doing the proper process. But the proper process, if there is an appealable issue from a state court decision, you file an appeal in the state court of appeals, or the state, whatever your state calls their appellate court division. So, there are exceptions, like if it's a habeas corpus, then that's different. But if you're just looking to essentially appeal a state trial court decision, it's not proper to take it to the federal district court. That's not the right place for it. And they also talk about Heck versus Humphrey. Heck versus Humphrey is basically you can't allege an improper prosecution or an improper conviction unless you get that improper conviction unless you get the improper conviction somehow overturned or pardoned or whatever. The conviction has to go away in order for you to sue someone basically for an improper conviction. I don't know if that makes sense. You can read Rooker-Feldman and you could read Heck versus Humphrey on your own. I don't really, this is going to be long enough without going into them. So this is the argument on immunity. This motion is brought on behalf of both defendants since both are entitled to absolute immunity. Defendant Justices of the Peace Atkins is entitled to judicial immunity. Judges and those performing judge-like functions are absolutely immune for damage liability for acts performed in their official capacities. Now, notice this says damage liability. Damage liability means damages, specific damages, i.e., like if someone rear ends your car, you could take your car, have it fixed. You have a specific amount of damage that was done to your car because you've got a receipt for how much it costs to repair that car, right? That's a specific damage. You go to the hospital because you hurt your neck in that car accident. The hospital sends you a bill. That bill is another specific damage. You're in pain from that accident, and you can't get it on with your wife, and you can't carry in groceries. You're in pain. Your life is kind of in shambles because this car accident has affected your ability to engage in normal daily activities. Those are general damages. There's no receipt for those. There's no specific monetary dollar sign attached to those. And then there's punitive damages, like if someone did something intentional, like if the driver behind you intentionally rammed you with his car. That might, if they're acting maliciously or fraudulently, you might be able to get punitive damages from what they've done. And punitive damages are just basically something that the court will give you. They'll give you punitive damages to punish the other party for doing the bad. So those are damages, right? So when the court says judges and those performing judge-like abilities are absolutely immune from damage liability for acts performed in their official capacities, they're specific. You know what? I think this actually, 42 U.S.C. 1983, perfect. All right, so we already know that judges are immune to damage liability for judicial acts. And then in 42 U.S.C. 1983, judges are also immune to injunctive relief, like where the court says you have to do X or you can't do X. Like a restraining order is a form of injunctive relief. If someone is constructing a building next door to you and you get an injunction, then they have to stop building that building, right? That's injunctive relief. And injunctive relief is not available against a judge, a judicial officer, unless the judge violated a declaratory decree, not degree, or declaratory relief is unavailable. So typically speaking, you can't get damages, you can't get money, and you can't get injunctive relief. Declaratory relief is what I was talking about the other day, where if there's a particular rule of court, let's just say rule of court that that judge has, and you can sue the judge for declaratory relief, saying that particular rule of court or what have you is unconstitutional. That'd be declaratory relief. You're not looking for an injunction. You're looking for the district court to say that you can't, or that particular thing is unconstitutional. And then there's also 42 U.S.C. 1988. And 42 U.S.C. 1988 says that the judicial officer isn't liable for costs, including attorney's fees, unless such action was clearly in excess of the officer's jurisdiction. Now, if you remember, the test for judicial immunity, for the damages, for being liable for damages, was the judge acting in his capacity as a judge, and did the judge have subject matter jurisdiction? Those are the two things. Or did he clearly not have subject matter jurisdiction? I guess is the better way to say it. The judge would lack the judicial immunity if the judge was not acting in a judicial capacity. If he was acting in an administrative capacity, he would not have judicial immunity to damages. But judicial immunity is also an immunity to suit. So, but let's stick on topic. And the judge would not have judicial immunity if he clearly did not have any subject matter jurisdiction. So the attorney's fees are going to be pretty rare. I probably should leave those up. So I put links to 42 U.S.C. 1983 and 1988 in the record. So the doctrine of judicial immunity protects judicial independence by insulating judges from vexatious actions prosecuted by disgruntled litigants. The rationale for granting judges immunity from liability for even intentional and malicious conduct while acting in their judicial capacity is that judges should be free to make controversial decisions and act upon their convictions without fear of personal liability. Notice there are a lot of Supreme Court cases being cited in here. I mean, this is well litigated. Judicial immunity applies, however erroneous the act may have been, and however injurious its consequences it may have proved to the plaintiff. Even when a judge is accused of acting maliciously, corruptly, or erroneously, the judge is still entitled to judicial immunity. Judicial immunity is not overcome by allegations of bad faith or malice. A judge is not deprived of immunity because he takes actions which are in error, are done maliciously, or are in excess of his authority. Like, for example, not returning a firearm. That might have been in excess of his authority. He might have been required by the statute to do it, but he's not deprived of immunity because he made the wrong decision. If, in fact, the judge in Grisham's case made the wrong decision, which we have no way of knowing because Grisham's still playing hide the ball. Such absolute judicial immunity is lost only when the judge acts in the clear absence of all jurisdiction or performs an act that is not judicial in nature. That's a restatement of what we've been talking about for the last, it seems like a week. An act is judicial when it is a function normally performed by a judge and the parties dealt with the judge in his or her judicial capacity. The court must construe these factors generously in favor of the judge and in light of the policies underlying judicial immunity. As indicated in the complaint, so in a motion to dismiss, you assume every fact in the complaint is true. Defendant Justice of the Peace Atkins' actions in his courtroom, including granting a continuance to the prosecution when the prosecution witness was unavailable, denying plaintiff's motion to dismiss the complaint, and finding the plaintiff guilty of the charges, are the primary bases for plaintiff's claims against this defendant. Clearly, the acts by Defendant Justice of the Peace Atkins are judicial acts. The Ninth Circuit has held that a clear absence of all jurisdiction means a clear lack of all subject matter jurisdiction. Now, remember, jurisdiction comes in three basic flavors. There's personal jurisdiction. Does the court have jurisdiction over you? The court has jurisdiction over you once you've been served with a summons, a complaint, a information, a citation. It's that service is how the court gets personal jurisdiction over you. There's also in rem jurisdiction, but let's not worry about that for now. Then there's territorial jurisdiction. For example, the courts of California they only have jurisdiction over California. California can only make and enforce laws in California. And then the final jurisdiction is subject matter jurisdiction. That is, are you in the right court? Can the court hear your case? A criminal court can hear criminal cases. A probate court can hear probate cases. A probate court most likely can't hear a criminal case. It's the wrong court. It doesn't have subject matter jurisdiction. California, we have one superior court that is the Court of General Jurisdiction, but the superior court can't hear appeals. Well, I guess technically there's an appellate division of the superior court that has jurisdiction to hear some appeals, but you get what I'm saying. The Court of Appeals doesn't have jurisdiction, subject matter jurisdiction, over trial court issues. You can't have a trial in the Court of Appeals. The Court of Appeals is for appeals. So that's subject matter jurisdiction. It's a fairly broad concept, and it's fairly easy to show subject matter jurisdiction. In this particular case, it was a traffic citation. It was a traffic case. It went to court in traffic court, where Justice of the Peace Atkins, I think it's technically Atkins. Yeah, Atkins, not Atkin. Where Justice of the Peace Atkins was the judge for that court. So, I mean, good luck, buddy, right? Where jurisdiction over subject matter is invested by law in the judge or in the court which he holds, the matter and extent in which the jurisdiction shall be exercised are generally as much questions for his, meaning the judge's determinations, as any other questions involved in the case. Jurisdiction should be broadly construed to effectuate the policies supporting immunity. Because some of the most difficult, embarrassing questions which a judicial officer is called upon to consider and determine relate to his jurisdiction, the scope of the judge's jurisdiction must be construed broadly. The Supreme Court in Stump illustrated the distinction between acting in the clear absence of jurisdiction and acting in excess of jurisdiction. Now remember, in order to get past judicial immunity, you have to show clear absence of jurisdiction, not excess of jurisdiction, clear absence of jurisdiction. If a probate judge with jurisdiction over only wills and estates should try a criminal case, he would be acting in the clear absence of jurisdiction and would not be immune from liability for his action. On the other hand, if a judge of a criminal court should convict a defendant of a non-existent crime, he would merely be acting in excess of his jurisdiction and would be immune. So there you go. If judicial immunity means anything, it means the judge will not be deprived of immunity because the action he took was in error or was in excess of his authority. Read that, Mr. Grisham. Quoting McCulley versus Chetigny, holding that the plaintiff's allegation the judge ruled on an untimely motion for reconsideration does not relieve the judge of his absolute immunity. Or Franceschi versus Schwartz, finding that a commissioner's reactivation of a bench warrant after agreeing to transfer the case to another judge was an act in excess of jurisdiction rather than the clear absence of jurisdiction. Or Mullis, bankruptcy judge's actions after debtor filed motion of appeal or notice of appeal may have been in excess of jurisdiction, but were not done in clear absence of jurisdiction. Or O'Neill versus City of Lake Oswego, where a pro tem municipal judge's action was in holding the plaintiff in contempt and office within his jurisdiction, although without the requisite papers to confer jurisdiction over this particular commission of the offense, is in excess of jurisdiction. Remember, we need to show clear absence, not excess, clear absence of jurisdiction. Even grave procedural errors are not enough to deprive a judge of immunity. In addition, a conspiracy between a judge and a prosecutor to predetermine the outcome of a judicial proceeding, while clearly improper, nevertheless does not divest the judge or the prosecutor of immunity. Now, I want to pause there, and I saw that Freeman the other day posted a video of two female police officers engaged in a fist fight, and he was asking which one of them would have qualified immunity from the charges. There is no immunity from charges, from criminal charges. Immunity applies to civil actions, to civil cases. So if the judge and the prosecutor collude to deny justice, they may be sanctioned by the State Bar Association, up to and including fines or disbarment or both. They could be charged by the state's prosecutorial branch. I mean, they can still get into a whole heck of a lot of trouble, but you can't sue them for it. That's the distinction. As long as the judge's ultimate acts are judicial actions taken within the court's subject matter jurisdiction, the judge is entitled to absolute immunity. To the extent that the plaintiff is attempting to claim the Justice of the Peace Atkins lacked personal jurisdiction over the plaintiff, the Ninth Circuit has held that a judge is entitled to immunity even if there was no personal jurisdiction over the complaining party. Clearly, the alleged actions by defendant Justice of the Peace Atkins were not taken in the clear absence of all jurisdiction. Accordingly, defendant Justice of the Peace Atkins should be dismissed from this action on the basis of absolute judicial immunity. Then they go on to talk about prosecutorial immunity. It's very similar to judicial immunity. They talk about the Rooker-Feldman, which prevents de facto appeals, except as habeas, I think. And then they talk about Heck versus Humphrey, which state that you have to get the conviction overturned basically before you can get a 1983 lawsuit to declare that your conviction is invalid or improper. So then there's the response. This is the response. This is Fred, Bobby Law's response. And boy, is it hard to read and get through. So he's opposing it. He goes over the allegations in the original complaint. First, he says the allegations have to be assumed to be true in a motion to dismiss. Absolutely, they do. And the allegation that was important as far as suing the judge was that the judge was his judge at the trial, and taking that to be true, you lose. The court's jurisdiction is conferred by statute or law. I don't understand what that means. Statute or what? Case law? Common law? I don't understand. Statute or constitution? Usually courts' jurisdictions are conferred by statutes or constitutions, generally speaking. However, it is initiated by following the law, including the statutes and rules that bring cases within its jurisdiction. It would help Bobby Law if he distinguished what jurisdiction they're talking about. This is obvious and well established. Well, if it was obvious and well established, then you wouldn't need to bring it up. For example, when statutory time limits on appeal aren't followed, C.J. Grisham, these appeals are jurisdictionally precluded from being heard, and this is stated as the court has no jurisdiction or this is outside the jurisdiction of the court. So the Court of Appeals has jurisdiction over appeals, and if a statute says you have this much time to file your appeal after the final order has been served on you or whatever, then that limits the jurisdiction of the Court of Appeals. So yes, he is correct. That would put the matter outside of the subject matter jurisdiction of the Court of Appeals. The court in question still has its power to hear those kinds of cases, but no jurisdiction to hear the specific case in question. Sure, that specific case in question would be outside of the court's jurisdiction, but would those kinds of cases, would it have the power to hear those kinds of cases that were outside of its subject matter jurisdiction because the time for filing the appeal had lapsed? I don't think so. I think you're making a muddy argument, sir. And then he quotes from the Federal Rules of Civil Procedure, more stuff about, Federal Rules of Criminal Procedure, and more stuff about the Federal Rules of Criminal Procedure, citing 42 CJS Indictments, Section 160. I don't know why he's doing that, because the court in Nevada that gave him that found him guilty of the traffic citation, or of the traffic infractions, or misdemeanors, I should say, the driving with no license and driving without plates, they had to follow the Nevada rules of criminal procedure, not the federal rules. So citing to the federal rules is dumb and wrong and a waste of everybody's time. In this specific case, there was no filed complaint at all. Does there have to be? Because he's suggesting that the federal rules of criminal procedure require a complaint, but does the citation count as a complaint under the Nevada rules of criminal procedure? This, in effect, put plaintiff in an impossible position of answering without notice to the nature and cause of the accusation. The citation would have given you that. It was a jurisdictional defect and not just a formal defect. Citation required. In other words, one which did not go to the heart of subject matter jurisdiction. Then he has this in italics. This court, without jurisdiction, precludes the judge from making an offer of a plea to the defendant in error without, in so doing, putting fraud upon the court. Now, is he citing U.S. versus Will? I could not find that language in U.S. versus Will. U.S. versus Will. 449 U.S. 200, U.S. versus Will. 449 U.S. 200. He cites section or page 216. I don't find that language on page 216. And by the way, this has nothing to do with judicial immunity or anything like that. So 216 is a very short page. This is it. Starts here, 216, and nothing in here about that. They're talking about section 455, which is part of it's talking about setting up the it's about commission. Anyway, where was it? Title 28 USC 461. These are all Title 28. So I don't know exactly what the hell he's citing to this case about, but it doesn't say anything like that, the court without jurisdiction. But then it goes colon, and then it starts a quotation. There's no end to the quotation. So I don't know if this is still U.S. versus Will, but there's nothing in U.S. versus Will that reflects this language about a duty to continually inspect. It doesn't exist. No duty to continually inspect. So I have no idea what that is. And it says also see Cohen's versus Virginia. And Cohen's versus Virginia. This Cohen's versus Virginia is, again, inapplicable, where this is where the Supreme Court was deciding whether or not it could hear a case about the interpretation of a statute, a federal statute that applied to the District of Columbia. These guys were selling these lottery tickets that were for the District of Columbia, and This is back from 1821, and it was illegal to do that in Virginia, but they were selling it in Virginia, and the court had to determine whether or not the United States Supreme Court had to determine whether or not the United States Supreme Court could hear that particular issue, and it determined it could. But it doesn't have any of this language in it about continually inspect the record. Let's search for that in Cohen versus Virginia. And it doesn't exist. So I don't know none of this language appears in either of the two cases. I don't know where he got this stuff. This is also not a proper citation. It's 19 U.S. 264. If you want to put that in there, it'd be 6 wheat. U.S. 6 wheat 264. If you wanted to put that in there, so it's an improper citation. But anyway, it's just, I have no idea why what the hell he's trying to say there. In regards to Bradley versus Fisher, since issuing its opinion in Bradley versus Fisher, the Supreme Court has continued to emphasize that a judge's immunity from civil liability is overcome in only 2 sets of circumstance. First, a judge is not immune from liability for non-judicial acts, i.e. actions not taken in the judge's judicial capacity. Second, a judge is not immune for actions, though judicial in nature, taken in the complete absence of all jurisdiction. I don't know what he's trying to say there, but this isn't helping him. The Supreme Court has also held that absolute judicial immunity was not affected or abolished by Section 1983, which makes, and again, he has quotes in here. I guess he's quoting Pearson versus Ray. But yeah, Pearson versus Ray does say that judicial immunity applies even to 1983 lawsuits, so this doesn't help him. To determine whether or not a judge is entitled to absolute judicial immunity, courts consider whether the act itself is a function normally performed by a judge and whether the judge acted in his judicial capacity. Yeah, congratulations. It was hearing a case about a traffic violation, driving without a license or driving with suspended plates, is normally done by the traffic court in Nevada, and the justices of the peace normally perform that judicial function in that traffic court in Nevada. So I don't know what he's going with there. Plaintiff in the original complaint reports that on numerous occasions, see original complaint, asked that Atkins direct opposing counsel to prove on the record the jurisdiction in the court had been initiated according to law. So I think he's talking about personal jurisdiction. He just doesn't realize it. And they've already dealt with personal jurisdiction in their motion for dismissal. Personal jurisdiction is irrelevant. Its subject matter jurisdiction is the only, at least in the Ninth Circuit, is the only bugaboo. So he doesn't understand the difference between personal jurisdiction, i.e. the jurisdiction over the person, and subject matter jurisdiction, i.e. jurisdiction over that subject. Once jurisdiction has been challenged, the court cannot proceed when it clearly appears the court lacks jurisdiction. I don't know who he's citing here. Well, let's look it up. Mello v. U.S. 505 F2D 1026. 505 F2D 1026. All right. Load, thank you. And what's the quote? Let's see if this quote actually appears there. Once jurisdiction has been challenged. This is from, okay. What circuit is this? So wrong circuit. Wrong circuit. This is 8th Circuit. But once jurisdiction... This is Mello versus U.S. This is 505 F2D 1026. This is 505 F2D 1026 Mello versus U.S. Once jurisdiction has been challenged, it doesn't exist. I hate sovereign citizens, man. I hate them. Let's see if it's in Joyce versus U.S. 474 F F2D 215. 474 F2D. Oh, I lost it. 474 F2D 215. 215. All right, Joyce versus U.S. Let's see if it's in here. And we're looking for once jurisdiction has been challenged. Nope. All right. Well, let's. Oops. What was the? So it's saying that in Joyce it says there is no discretion to ignore lack of jurisdiction. It's finding the court lacked subject matter jurisdiction. Sweet. What page did he cite? Oh, of course, he didn't cite a page. Discretion to ignore. All right. Where there's no jurisdiction of the subject matter, there is as well no discretion. So he's mixing together personal and subject matter jurisdiction. But let's see if we have immunity. Oh, it's sovereign immunity. Huh. Yay. No talk about judicial immunity. So it's an off-topic case. What circuit is it in? What circuit are you in? You are in the Third Circuit. Again, the wrong circuit. So congratulations, SovSit Research once again wins. Therefore, without the jurisdiction in the court being initiated per Nevada revised statutes, which jurisdiction, subject matter or personal, because again, the summons and complaint, or that's civil action, the complaint or the information or the citation gives the court personal jurisdiction over you. So again, he's mixing up personal and subject matter jurisdiction. Such absolute judicial immunity is lost only when the judge acts in clear absence of all jurisdiction or performs an act that is not judicial in nature. So, he actually cited the Right Circuit, Ninth Circuit, 1988, but did that overrule the case in here. We don't want prosecutorial immunity. I told you this would be long, and I apologize. Miller versus Davis, 9th Circuit, 2008. He's citing 1988. The newer case wins. It needs to be subject matter jurisdiction. Clear lack of all subject matter jurisdiction. So, sorry, buddy. But at least you got into the right circuit this time. And you actually gave a page citation without just... Well, let's look at it. Since he's batting so well on these, 846 F2D 1202. 846 F2D 1202. Checker. There we go. All right. And it is the correct circuit. And let's see if the quote exists. What is the quote? Clear absence of all jurisdiction. Clear absence of all jurisdiction. All righty. Looks like it's in here, so that's good. So that is awesome. And then let's look at this. Does not have subject matter jurisdiction. So interesting. Well, it's actually worse if it has to be... So just so you know, it's worse for Bobby Law if it requires that the court has clear absence of all jurisdiction, because there's personal jurisdiction. The court might have personal jurisdiction over you, but not subject matter jurisdiction. And if it was clear absence of all jurisdiction, in that case, the judge would have judicial immunity still. So it's better that it's just when judges have subject matter jurisdiction. That way, all you have to do is show that Atkins didn't have subject matter jurisdiction, and you don't even have to worry about the personal jurisdiction. Without jurisdiction in the court being initiated specific to plaintiff's matter, again, he's talking about personal jurisdiction, all acts of Atkins were not judicial, including proceeding in absence of a proper arraignment, entering a plea for plaintiff. I knew he entered a plea for plaintiff. Proceeding to trial and sentencing. A judge who acts in clear and complete absence of personal jurisdiction loses his personal jurisdiction, loses his judicial immunity. So this is Rankin versus Howard, 633 F2D 844. 633 F2D 844. Let's see what we got here. All right, so Ninth Circuit, 1980. So the 2008 case is newer. Personal jurisdiction. All right. So that's a good quote for him. It's just wait a minute. Kansas statutes? Why are they talking about Kansas statutes? Interesting. Well, unfortunately for him, it's old. And well, also unfortunately for him, he had a citation, so the court had personal jurisdiction over him. Further defense, complete recital of the judicial immunity doctrine, however, only cite a portion of the prosecutorial immunity. Okay, we don't really care about that. Due process. Oh boy. So he's saying that that Atkins was entirely inept for the reason that his education is of such a deficient nature that it deprives substantially every defendant that comes before him their fundamental right to a fair trial. Oh God. Anyway, all right. Let's go to the order. All right, so they recite the facts, they recite the legal standards, and then the analysis. The court grants a motion to dismiss for two reasons. First, no action is permitted under 1983 if a verdict in favor of the plaintiff would imply the invalidity of previous conviction, that's Heck versus Humphrey, in order to recover damages for allegedly unconstitutional conviction or imprisonment, or for other harm caused by actions whose unlawfulness would render a conviction or sentence invalid. A 1983 plaintiff must prove the conviction or sentence has been reversed on direct appeal, expunged by executive order, declared invalid by a state tribunal authorized to make such determination, or called into question by a federal court's issuance of a writ of habeas corpus. Plaintiff has not alleged such facts. Second, both defendants are absolutely immune from suit as a general matter for their acts related to their respective judicial and prosecutorial functions. A judge is not immune, however, when he acts in clear absence of all jurisdiction. That's stumped. For example, if a probate judge, blah, blah, blah. We've read that before. So plaintiff complains he was not presented with a summons and complaint or any other charging instrument. But these kinds of errors, even assuming there has been this type of error here, do not demonstrate a clear lack of all jurisdiction. Justice courts have jurisdiction over misdemeanor crimes he's talking about. So when he says justice courts have jurisdiction over misdemeanor crimes in Nevada, he's talking about subject matter jurisdiction. That ends the analysis. Justice courts have jurisdiction over misdemeanor crimes in Nevada. That ends the analysis. Justice courts have jurisdiction over misdemeanor crimes in Nevada. That ends the analysis. So long as the justice of the peace was purporting to try plaintiff for a misdemeanor crime or lesser civil infraction, which is clearly the case, judicial immunity applies. That ends the analysis. So if we apply this to C.J. Grisham's case, the judge had jurisdiction over that case and over returning the gun. That ends the analysis. So part 3 is still to come. It's another crap fest. I apologize about it, but it's going to be a long one. Thank you for watching. Have a great day.